So what happened at the first hearing, and that was back in
November 1st.
November, thank you. What happened in November?
Your Honor, I originally prepared the stipulation in order, setting it for November 1st, believing that I would be off medical leave by then. Unfortunately, I calendared that on my Harris Law calendar, and about 2.5 weeks after that, they turned off my access to everything electronic while I was on medical leave.
And that's when you left and went on your own soon thereafter?
I am still technically at Harris Law until my medical leave expires, which has been pushed to the middle to end of this month.
So you still don't have access to calendars?
I now have my own calendar, but the original November 1st date was on the Harris Law calendar, and I, by oversight, missed that in adding it to my new calendar.
All right, and then what happened last month?
The morning of, and I can pull it up, but the morning of that date, I had another adjourned trial that, again, I had believed that I would be off medical leave by that point, and I can just pull up the date.
It was December 1st that I had to go.
December 1st. Okay. So that same morning, my client called. I had calendared for December 3rd, 2 days later, a trial in Charlevoix County. My client had called me that morning and inquired about the trial that afternoon. I contacted the court. They confirmed that it was in fact scheduled for that afternoon, and that put me in a position to really
appearance at 1.
Part 1. The judge confirms there are no oral statements required for the show cause review. The hearing quickly shifts to assessing the overall status of the case.
So what happened at the first hearing, and that was back in
November 1st.
November, thank you. What happened in November?
Your Honor, I originally prepared the stipulation in order, setting it for November 1st, believing that I would be off medical leave by then. Unfortunately, I calendared that on my Harris Law calendar, and about 2.5 weeks after that, they turned off my access to everything electronic while I was on medical leave.
And that's when you left and went on your own soon thereafter?
I am still technically at Harris Law until my medical leave expires, which has been pushed to the middle to end of this month.
So you still don't have access to calendars?
I now have my own calendar, but the original November 1st date was on the Harris Law calendar, and I, by oversight, missed that in adding it to my new calendar.
All right, and then what happened last month?
The morning of, and I can pull it up, but the morning of that date, I had another adjourned trial that, again, I had believed that I would be off medical leave by that point, and I can just pull up the date.
It was December 1st that I had to go.
December 1st. Okay. So that same morning, my client called. I had calendared for December 3rd, 2 days later, a trial in Charlevoix County. My client had called me that morning and inquired about the trial that afternoon. I contacted the court. They confirmed that it was in fact scheduled for that afternoon, and that put me in a position to really.
Counsel explains that discovery responses were received earlier the same day, although not fully reviewed. All questions appear
because it was in person and it was with an incarcerated individual, and that put me in the position of scrambling to try and find coverage because another attorney isn't going to cover a trial.
Well, you also could have just contacted me to see if I'd be willing to adjourn the hearing. You could have contacted Mr. Vernon and asked him if he'd be willing to stipulate to move it to a date you didn't have a conflict.
I did attempt to call Mr. Vernon, and I left, I believe, 2 separate messages for him, and I believe I emailed. I can't confirm for certain the email, but I did call his office twice.
Why did you not contact my staff?
Honestly, Your Honor, I didn't think without Mr. Vernon's consent that you would entertain that.
Ms. Bailey, quick, conflicts, as I explained already, come up all of the time. And that's not new. It's newer and it's harder now with Zoom because you are expected to be in more places than generally before 2020. But I can tell you with 100% certainty that if I got a call from any attorney who explained they had a conflict in an in-person hearing, I would do one of two things. I would either, one, call the other judge and have a communication about moving both hearings so they could be accommodated, or I'd just move on my own motion a hearing. Because I don't expect you to be at two places. But I certainly expect more than lack of communication to my office. I'm the one who ordered you to show cause. And the position you left me in was to decide whether to order you to appear this way in person or to issue a bench warrant. And I don't want to do that because I know what that means for attorneys. And I know the schedule that you keep. But you put me in a terrible position when you could have simply done it differently. My point in bringing this up is I expect it to be done differently because I don't want to have show causes. I don't want to order attorneys to appear in person to have discussions about not appearing at court dates. And if I didn't think there was good cause, I do. There's good cause in the sense that you had a conflict. You didn't.
Defense counsel confirms all requested discovery, including extensive documentation, was provided. The court determines there are no outstanding discovery compliance issues.
Handle it in my estimation correctly. If I have that type of activity again, I'm not going to look at just having a discussion about it. This is simple notification to the court. And that's what I expect, is if you have a conflict, you notify me. And that's what the court rules require, is if you have a conflict, you immediately bring it up to each court that you have a conflict with. So read those rules if you haven't before, follow them in the future. Do you have any questions about what I've said so far?
I don't. I understand the court's position, and I want you to know it wasn't intentional or deliberate or just trying to be disrespectful. I understand the court's position now, and I, at the moment, with a very little bit of time, thought I was doing the right thing by finding coverage. So I again apologize. I now understand the court's position and what should be done.
All right. Mr. Vernon, did you wish to offer any oral statements for purpose of the review of the record for the show cause matter?
No.
In terms of status conference, then, Mr. Vernon, as plaintiff's counsel, where are you at in this case? I know there were some discovery issues and I issued an order. Do you have the discovery you need? Are you still working to receive that? Where are we at?
So we received what I believe are the answers to their discovery. We received them about noon today. So I haven't had the opportunity to review them with my client. It does appear that the discovery has been provided. So I think they are in compliance with their discovery demands. I don't know where that puts us other than, we're still reviewing it.
All right. You don't have anything outstanding as far as you're concerned, though.
I'm sorry?
You don't have any outstanding requests that have not been, I know you haven't gone through them in detail.
No, it appears that all the questions we sent over have been answered. I don't know if they've been answered fully, but it appears just by flipping through that there's an answer in each category. So,
which had paused while discovery was pending. Both sides agree mediation should resume now that information has been exchanged.
Well, Ms. Bailey, quick, I know you weren't expecting this to be a status conference, but just from your standpoint, do you believe you've supplied all of the outstanding discovery that's been requested?
I brought a copy with me today on December 15th. I did provide everything but the signature from my client, who I got, I believe, a day or two later. And I provided all 244 pages to Mr. Vernon on December 15th. So
All right.
I believe it has been complied with.
Are you awaiting discovery? In other words, I'm trying to get a sense of when I should set a next status conference and what I need to do to facilitate the parties working towards either resolution or knowing that you need to be prepared for trial.
I have not requested of Mr. Vernon more fully or complete answers or documentation because my client wants to get this case resolved. We left off with whether or not we were going to go back to mediation. That is where I believe we're at. I provided Mr. Vernon with the parties' oral agreement from back in, I believe they had the conversation early within the first quarter of 2025. I provided that quite some time ago, long before December, to Mr. Vernon. My client's position hasn't changed, and just need to know at this point whether we're going to continue mediation or if we just need to set the matter for trial.
Well, did you start mediation and then pause it to get more information, or did you just complete it and it wasn't successful?
At that point, Mr. Vernon asked for more information.
Mr. Vernon, is that accurate in terms of at the mediation? You started it, you didn't continue and finish because you wanted to get the discovery that maybe was subject to that last motion?
Yes, the parties were pretty far apart at that point, so we just said there wasn't any real point moving forward. So we got additional information. I think the expectation was that once we got it, we would return to mediation.
All right. Well, who are you using as a mediator? Were you just doing the facility or the
Community
community
mediation.
dispute resolution services? I'm going to order that you return to that mediation. I don't have a problem, Mr. Vernon, if you tell me you need a little bit of time to go through the discovery, if it was 244 pages before you do that. But given your representation that that's already what the plan was, do you have any reason to oppose that?
I do not.
Do you, Mr. Lakewood?
I do.
You do?
No, I do not.
Oh, all right. So I'll order that. How long do you need to return to the mediation then and decide whether or not you have a possibility of resolution or whether or not the court needs to just calendar for trial?
I would defer to Mr. Vernon. I'm ready to go.
I think the court, or I think the community mediations tend to schedule things 2 to 3 weeks, maybe 4 weeks out. So I think as soon as we can get into mediation, we'd be ready.
Well, that's what I'll order then. I'll order that you return to mediation within 1 month. I'll set a status conference next month. If for some reason there's a problem with scheduling because of the, the backlog with the holidays, just let me know by stipulated order and we can move the status conference. I don't need to hear from the attorneys until I really know. The ultimate question is if you've settled the case or if you need me to hear how long you need for trial. Any problem with that, Mr. Quick?
No, yeah.
Mr. Vernon?
No, Your Honor.
All right, that's what we'll do. We'll see you next month by way of status conference unless I hear that you need more time. Thank you.
The judge orders mediation to occur within 1 month and schedules a follow-up status conference. The goal is clear: resolve the case or prepare for trial without further delay.